Okay.
Good to go.
All right. Good afternoon, and thank you so much for joining us for another Self-Directed Saturday with Quest Trust Company. We are so happy to have you here. My name is Nicole Bako, and I am an IRA specialist at Quest, and I will be your host today. Today, we have a very special webinar for you. It was so wonderful the first time that we did it with Eddie Gant that we had to show it again. But here with us from Jet Lending is Alex Buriak, who will be here with us to help answer questions at the end. But before we get into this amazing seminar, I wanted to share a little bit about Quest, who we are, and what we do. All right, there we go. All right, so thank you so much for joining us for Self-Directed Saturday. Oh, come on, little computer. There we go. Who is Quest and what exactly do we do? So Quest Trust Company was actually started by two brothers, Quincy and Nathan Long. They started the company as investors and built the company for investors around with the client experience that it should be, since they were active investors themselves. And a lot of us at Quest as employees are active investors ourselves. So Quest is an IRA custodian here in Texas. We're based out of Houston. We do have offices in Dallas and Austin as well, but we do service the whole country. So no matter where you're joining us from right now, we can help you. So as I said earlier, we have 20,000 live active clients. This slide's a little old, I bet it's more than that now. We do have 2.1, that's up from just the 2 billion assets under administration. And another thing that's really important to point out right now, especially since we're going to be talking about real estate and notes, is that we have $400 million in client cash that's not invested, just waiting for an opportunity to come around. So keep that in mind, for all of your investment needs that could come up. There's money out there to fund it. Of course, our disclaimer, this webinar, like all of our webinars, is for education purposes only. Quest does not provide any legal, tax, structuring, or investment advice, and we strongly encourage you to do your own due diligence on your investments and the people you're investing with, and making sure that you are contacting your CPAs and attorneys before engaging in an investment. All right, so what is a self-directed IRA and why should you have one? So honestly, self-directed is just a marketing term, and it means you are in the driver's seat. You get to direct the funds exactly where you want yourself. So here at Quest, we only hold private investments, and we have the platform that allows you to invest in a lot of these alternative investments. So some benefits, of course, the tax savings. The traditional and our Roth IRA, along with some of our employer plans, have amazing tax savings. One of my favorite accounts is the Roth IRA. After having it open for 5 years and reaching 59 and a half, you get tax-free and penalty-free distributions. Very exciting. So making sure that you're contacting your IRA specialist to see how this could work for you. Of course, social investing, when you're improving properties in your community or doing like an owner finance for someone who can't get a traditional mortgage, you're really making a difference in your community and improving it that way. So that's really special. That kind of is different than just investing in the stock market. And of course, invest in what you know best. If you have a lot of education on real estate, promissory notes, oil and gas, etc., this is where you can use your education to really help you save for retirement and invest in things that you really know about. So these are the 7 accounts here at Quest Trust Company. We have personal plans, employer plans, and our 2 amazing specialty plans. I'd love to tell you more about all of them right now, but we just don't have the time. So make sure you're contacting your IRA specialist to get a consultation and see how we can help with this. Investment choices. These are the 3 main asset classes that people invest in at Quest: real estate, private entity, and of course, promissory notes. But I would say, honestly, this is a short list. Oil and gas is not listed on here. We have seen some really creative things. We have clients that have cattle in their IRA, so really wide open. So make sure, again, you're connecting with your IRA specialist to see which one is best for you. This is something that we're really excited about, really proud of, our new client portal. We relaunched this in April. Now you can do all of your investments on the portal. You can upload your fair market value, get all your statements, upload documents to us. So make sure you're checking that out, really using the portal. It's got tons of advantages to really help you out with your account management. And of course, we offer endless education, like the webinar you are on right now that we hold every Saturday at noon. We do have an exciting event coming up at all 3 of our offices in September. So next month in Houston, it will be on the 7th, Austin the 14th, Dallas on the 21st. So this event is limited to 50 people only per office. So make sure that you sign up for this quickly. We are going to have, this is a hybrid event, so it will be online as well. And of course, we ask if you did buy a ticket and then find out later that you're not going to be able to make it, please make sure you cancel your reservation so somebody else that can get there. So make sure you check that out on our website. And I know our lovely moderator, Sarah, is putting all this information in the chat box for you. Here are more self-directed IRA resources. In addition to self-directed Saturday, we also have a Tuesday, Thursday class at noon with more guest speakers, more webinars, more information on investing and diversifying your portfolio there. Our YouTube channel is amazing. Our marketing team works so hard to really keep that up. This webinar is actually streaming there live now, and you can find it under the video sections after it ends, along with all of our other webinars that we save there for you. The YouTube site also has tons of information about the account types, investing, the process, lots of education there, so make sure to check it out. And then, of course, our website, questtrustcompany.com, also offers tons of the class archives. Sarah's amazing blog is on there. You have to check it out. And we have our own education center on there as well. And of course, our virtual networking happy hour that happens the 1st and 3rd Wednesday of every month. Virtual, we'd love to have you. This helps you connect with other investors all across the country, get to ask them questions, see what everybody's investing in. Everybody gets about a minute on camera to say why they're there. And then everybody shares their information in the chat box to connect offline later. So make sure you're signing up for that event too. It's really fun. So come have a glass of wine with us. We love to have you. Of course, self-directed Saturday, every Saturday at noon. And then, so it pays to have friends at Quest. If you are a Quest client and you refer someone and they open an account, make sure they use the code referral on their application and include your name. You will each then get $25 as a credit to your account for being a friend of Quest. And our monthly promotion that we extended from July to August. So don't read the disclaimer at the bottom. It doesn't have to be by July 31st. We extended it for August. So you can see the qualifying deposits on the right and the amount of fee credits will credit towards your account for that amount, up to $500 in fee credits. So making sure that you're talking to your IRA specialist, current client, new client, everybody is eligible for this amazing reward. Of course, how to get in touch with us. We're really easy to get in touch with us. You can scan that QR code right now. It really does work. I tested it. Chat live with us on our website. The IRA specialist and the transaction specialist actually man this. So it's not a robot. I get that question a lot. Of course, 8:30 to 5:30, Monday through Friday. We'd be happy to chat with you and answer any questions that you may have. Or give us a call. I love our phone number, 855-FUN-IRAs. We really do make the process fun and as painless as possible for you. Or of course, email us directly. Our general email box is iraspecialist@questtrust.com. And you can reach out to me specifically at nicole.baco@questtrust.com. All right, that is quite enough for me. I know that you really here to come and see the amazing webinar by Mr. Eddie Gant, who runs Jet Lending. We have Alex with us as well. That's going to help us with questions. And today's topic, tips and traps of the TREC. Say that 3 times fast. So this is kind of structuring on your real estate investment. So without further ado, here is your video. I hope you enjoyed as much as we do.
Good evening, everyone. Eddie Gant here in Houston, Texas, coming to you from the studios at Jet Lending in North Houston. So anyway, I am doing this at the request of a couple of organizations. I do a lot of these. I cover a variety of topics. Today, we're going to be talking about writing special provisions you should be putting in your contracts as a real estate investor. A little bit about me first. I've been a Quest customer for 20 years. It's a great organization. If you're don't have a Quest Trust account over there yet for your old self-directed for your old 401ks to roll it into a self-directed IRA, you need to get on that bandwagon. It can be a rocket ship for you if you make good investments on your own. Self-directed because self being you direct where the money goes. So, Eddie Gant, Jet Lending. Hope you like my little background here. I kind of cover up the airplane, but there's a big jet behind me here. I've been in the real estate business 21 years. I left my corporate job. I have a degree in civil engineering. I did a lot of concrete, steel, construction materials over about a 16-year career. I left that industry in June of '99, and the next day I was in the real estate business. I have bought, purchased, rehab, resold somewhere just north of, I think it's 1,700 houses now. Maybe off on that number, but I'm pretty close. 1,700 houses. That's a load. We started Jet Lending 17 years ago. We're fairly prominent in Texas, I feel, have a great reputation. We can loan you money for your flips. We can loan you money for your long-term rentals. We do loans for real estate investors only. We do not provide lending services for what we call owner-occupant buyers. In other words, you're going to buy it and live there. We're not in that business. We're known for our speed, our integrity, our dependability to be there for you on closing day. So come see us. We work with a lot of Quest folks that have money on the sidelines, sitting over there in an account not doing much. The Quest clients they do on a fairly vast size, loan their money to Jet Lending. We loan it back out. We make the spread. The Quest client gets the very nice fixed rate return. We handle the servicing. If it should go into default, the loan going into default, we keep paying the Quest client. We take the hit, and we handle the unfortunate proceedings to foreclose and take the property back. So it's been a win-win for everybody. In 17 years, Jet Lending's never missed a payment to a bank or a private individual or to a self-directed IRA account. Has not happened. But anyway, let's get down to business here. Enough of the salesmanship. You're going to have to bear with me just a little bit here. Keep this in mind as we go through. I'm talking about being a buyer. I'm talking about being a seller. I'm going to do my best not to confuse you. I may have to back up every now and then. I'm going to do my best not to misspeak, because sometimes I'm going to be talking as a buyer. Sometimes I'm going to be talking as a seller. And I use special provisions totally different. To be honest with you, I use the TREC contracts, and I use them a little bit differently depending on if I'm buying or selling. I'll go into that a little bit. So let's talk about first. I am talking to you first. I am an investor, real estate investor. I'm going to be purchasing. So I use the TREC contract. You can either write in special provisions. When they revised the TREC contract, I think the last time they revised it was in 2019, and this change I'm about to describe to you may have been 2018, but they took the special provisions section from about this large of a paragraph down to about this large of a paragraph space. You're very limited to do a lot of special provisions there. So what we do a lot of times, we'll type in the special provisions section. We'll say, see attachment A, and then we'll have a complete attachment for our special provisions. If you follow some of these, the end result is going to be, you're going to be a little better protected. You're going to have a little bit better leverage in your negotiations. You're going to save some money on some of them. You're going to decrease your heartache in this business, because it's full of little things that pluck monies out of your pocket. It's full of little things that just give you trouble. So let's jump into it. Special provisions as a real estate investor buying and investment property. I am not an attorney. I'm just an old businessman who's got a lot of experience and bought 1,700 houses, okay? Do not take legal advice from me. Consult your own attorney on these. But just use this as what I'm going to say, good real estate investment advice from somebody with some experience. I am not a real estate attorney. Seek your own counsel for legal advice, please. I always state in my contracts when I'm buying, Eddie Gant is a principal of such and such company. I have multiple that's buying the property. Eddie Gant is a principal and is a licensed real estate agent in Texas. I still put that in special provisions. For those of you out there that know this TREC contract backwards and forwards, yes, I'm aware Section 4 is where you put it. We do it twice. There's nothing wrong with stating it twice. We do state it on page 1, Section 4, that I'm a principal in the buying entity and I'm a real estate agent. But we go beyond. We don't ever want to be accused of not providing proper disclosure. So I will put it in 2 places. But Section 4 didn't exist to just a couple of years ago. We used to have to write it in special provisions. Okay. All right. Moving on. The second one I want to give you. We write our contracts up as cash. We always have. We probably always will. Many times, I'm actually getting my funds from one of my bank credit lines. Okay. So technically, it's a loan. Okay, technically I'm getting money from a lending institution. That lending institution is going to file a deed of trust, have closing instructions to the title company. But for negotiation purposes, I write them up as cash. So therefore, so I don't get myself in trouble with the seller or seller's real estate agent or the title company or the state of Texas, I will write this into special provisions. Funds for this transaction are from a cash credit line and do not require appraisals or pre-approvals. I'll restate. Funds for this transaction are from a cash credit line and do not require appraisals or pre-approvals. Okay? That gets me off the hook for someone to say, hey, you're getting a loan here, but you wrote it up as cash. Okay? All right. I don't have it on my sheet here, but I'll improvise here. You could state it a little bit differently. You can state on it, buyer is getting a loan for the purchase of this property, but this contract is not contingent upon getting funds from a lender. Another kind of a different way you could put it. Okay, again, the things you want to accomplish here is keeping your leverage because it's a cash offer and keeping yourself out of hot water with anyone who might accuse you of misleading that you're actually getting money from somewhere else, even though you wrote it up as cash. I'm a firm believer that you can write them up as cash all day long and just make the contract not contingent upon receiving those funds, and you're in good shape. For those of you that's going to use a hard money lender like Jet Lending, you'll have to change up this special provision just a little bit. Remember, I said funds for this transaction are from a cash credit line and do not require appraisals or pre-approvals. Well, that really wouldn't be true using a hard money lender because they're going to get an appraisal pretty much every time. So you might want to just say funds from this transaction are from a cash credit line or hard money lender and it's already approved, or whatever language you want to put in there. Okay, you can just change up the words there. What you don't want to say if you're using a hard money lender is do not require appraisals, because that's probably true. They will require an appraisal. Okay, all right. The next one is a money saver. For those of you watching, I am drinking Diet Coke only and ice here, not my normal beverage of choice at 6 p.m. Okay, all right. This one will put money in your pocket. potentially. Tax prorations are based on non-exempt values. Tax prorations are based on non-exempt value. The best way to tell you the advantage here is to take you through an example. Okay, let's say you're buying a house from a 85-year-old lady. For this example, we'll call her Myrtle. Okay, you're buying it from Myrtle, and you're actually closing this transaction October-ish. Okay, the house is worth $300,000. The tax bill is $650 a year. That's all it is, because she's got all these exemptions and has had the over 65 exemption now for 20 years. Okay, you buy this in October. If you did not have this special provision about the non-exempt values in your contract, you would get a whole whopping $400 thereabouts credited to you on the settlement statement for the tax prorations for the current year. All right, now let's go to January. You still own the property. Potentially, there's a really good chance you own this property in January. You haven't had a chance to have it updated, marketed, sold, and closed yet. There's a really good chance that in January, the tax authority wises up, sees Miss Myrtle doesn't own it anymore. Big bad evil investor owns it. And they remove all of those exemptions that Miss Myrtle had. And you have not paid current year or previous year's taxes yet. And you get hit with the $3,500 tax bill. Okay? And I know what you're thinking out there. You say, well, I didn't own it but for 3 months. I can go fight that. I can go back to Miss Myrtle and get it. Good luck. I'm going to tell you, from someone who's been down that path many a day, you're not going to win that. You're paying that $3,500 when you sell that house, or by January the 30th, if you pay the tax bill on time, you're paying the $3,500. You're not going to win. And I'll wager anything you want to wager on that. I've been down that path too many times. So let's back up a little bit. You're at the closing table in October buying it from Miss Myrtle, and she didn't remember you telling her about non-exempt values. She didn't remember this going in, and she's probably in the closing room with her son, her daughter, her kids, there to protect her, and they push back. So we're not doing that, because instead of that $400 from Miss Myrtle, you're getting off non-exempt values, you're getting $2,000, $2,500 that day. And they push back and push back hard. Contractually, you're correct. You will have to make a business decision. Do I give? Do I not give? Do I give? Do I not give? How stern in your approach do you want to be? And that's a business decision for you. You can hold them to the fire, feet to the fire on the non-exempt values and get the $2,000, $2,500, or you can be a softy and give in. It's a business decision, and it's up to you. What you don't want to do is sneak this in there without telling them at the contract time. That's just not right. So don't do it that way. But you need to be aware you could get pushback on this situation. But explain it properly, explain it up front. Get your $2,000, $2,500 tax prorations in October, and then tax bills due next year when you sell it. You'll see very quickly you're ahead of the game a couple of grand on this deal. I've been down this path, I don't know how many times. I haven't won one yet, so just be aware. Okay, all right. I'm moving on. You don't ever want to be accused of taking advantage of someone. So this next one is really good. I don't think it's a legal issue. It's just keep your butt out of trouble. If you ever got called in front of a judge, you don't want to sit in there trying to defend yourself later that you didn't take advantage of someone when you really didn't. So I'll put this in there. And this is a good one. Seller understands that the buyer is a real estate investor that purchases properties below market value with the intent to resell for a profit. I'll read again. Seller understands that the buyer is a real estate investor that purchases property below market value with the intent to resell for a profit. Okay? So, later, if the seller gets mad at you for whatever reason and says, hey, you offered me too low. You took advantage of me. My house is worth more than that. You didn't give me a fair offer. Now, don't get me wrong. This does not happen often. It almost never happened. But if it did, wouldn't you a whole lot rather being in front of a judge in a courtroom and having your sales contract or your purchase contract when you bought the house and say, look here, Mr. Judge, I said right here, this is a special provisions. It's right there. They initialed off on this. They signed it. The seller understands that I'm a real estate investor that purchases property below market value with the intent to resell for a profit. I told them, I didn't hide this from them. I think that'd be an awful good thing to have. Okay. All right. Next one. A lot of us buy houses that are vacant, and we like to get a head start on marketing and bidding on repairs and things of that nature. So I'll put this in. If it's vacant. Now, I know some of you do this when it's not vacant, but I don't. Seller to place a key, or you could say seller to give buyer a key, to place in a lockbox provided by the buyer to be placed on the front door for contractor bidding purposes. So get that key, put it in a lockbox, and put it on the door. If it's vacant, I gotta tell y'all, if it's not vacant, I do not do that. In my opinion, nothing's good coming out of that. The first thing that's going to happen if that property is occupied by the seller or seller's family or someone else, and you have a key and something comes up missing over there, who are they going to blame? So I will not do it on a house that's occupied, okay? All right. But I do that, and it gets you a head start on your contractors, and it allows you to market the property. You could send, potential buyers by. I don't think you ought to send a buyer without being with them or having them escorted by a real estate agent or someone. But it gets you a jump on things. Okay? All right. Kind of the same slant to this next one. Seller to grant buyer permission to market the property for sale prior to closing. Seller to grant buyer permission to market the property for sale prior to closing. There's multiple reasons for that. If you're an agent, you've got to have permission from that current owner to market the sale. That's one reason. You don't want to get yourself in trouble. If you're not an agent, it's still good for you because you don't want the seller saying to you later, wait a minute, you don't even own it yet and you're trying to sell it. It just eases those feelings over and gives you permission to go in and out, visit the house, go in and out, use the key. The seller's giving you permission to do that. Because remember, at this particular time, you're only under contract to purchase. You're not the owner yet. So it's just good to get those permissions and do that. Okay. All right. Now, here's one that's like the tax prorations that will put some money in your pocket. This is probably the biggest, most important one on here in terms of saving you money. Here's the situation, and I'm going to tell it just like I say it sometimes. You go to the house, you look at it, and the house is full. It's full of junk. From the floor to the ceiling, wall to wall, front to back. It's full. You go to the backyard or the side yard or garage, and it's full of, miscellaneous steel products, old appliances, just tons of tires. It's a lot of stuff, And you say, Okay, Mr. Sutter, who's going to remove all this? Do I need to allow for dumpsters and labor to come remove all this stuff? And every time they're going to say, oh, we'll handle it. All this will be cleaned out. We're going to handle it. Okay? I'm going to say 80-90% of the time, the day you close, all the stuff is still there or a big portion of it. And I'm going to tell you, dumpsters and labor is a lot more expensive than it used to be. I know. So this will save you a lot of money. So what we write in here is property to be broomed, clean, and free of debris prior to closing and funding. Property to be broomed, clean, and free of debris prior to closing and funding. And I got little parentheses out here. This is not for your special provision, just for you. Verify. So, what you're going to want to do, excuse me, what you're going to want to do the day of closing or the day before closing or maybe 2 days before closing, go to the site, go to the house. Okay? All right. And you pull up and you're supposed to be closing at 2 o'clock and you go by there at 11 o'clock in the morning, all that stuff's still there. You got a problem. This will save you $3,000, $4,000, $5,000 every time. So, what you can do, if you're there at 11 in the morning versus 2 p.m., you can hold up the closing. I don't know if I recommend that. What I really recommend is take the one I just gave you, property to be broomed, clean, and free of debris prior to closing and funding, and add this. Add something like this to it. Buyer to withhold $4,000, $3,000, $5,000. To withhold and hold those funds in your possession at closing until this special provision is met. Choose your own wording on that. But we do that all the time. Buyer to withhold $4,000 at closing if not broomed, clean, and free of debris. It's right there. And I'm going to tell you what happens most of the time. When they really got that much stuff, at the end of the cycle period where they're getting ready to sell it to you and close at the title company, they get tired, they get frustrated, and they just walk away from the house and leave all the stuff there. And they know that special provision's there, and you don't get that pushback at closing. So you actually put an extra $3,000 to $5,000 in your pocket. I say put it, well, you use that to clean it up. But if you didn't have that, you'd be paying for that same cleanup and debris removal and paying for it out of your pocket. This one saves you money. And that's very, very, very important. Okay? All right. Okay. Here's some other things when you're buying. A lot of you, listen to this, probably haven't bought 1,700 houses, and you may not have bought any yet. You may only bought 1 or 2, and you get nervous about these deals. You're really nervous about them. You don't know if it's a deal or not. Well, let me tell you something. If it's a deal and you hesitate and you procrastinate and you're kind of scared, you're scared to pull that trigger, somebody else is going to get your deal. Somebody else is going to come see it and not hesitate. So what do? You don't know if it's a deal. You don't know if these repairs are $20,000 or $40,000. You don't know. A little iffy on it. So we'll put you, the main thing is get them under contract. Okay? Get them under contract, but if you're nervous about it, give yourself some protection. And there's multiple ways to do it. Let's talk first about special provisions. You can simply put, this contract is contingent upon lender approval. This contract is contingent upon jet lending approval. That'd be a good one. I like that one. That'd be a good one to put in there. Okay? Because we're going to tell you, and we're going to tell you fast. I mean, I hear this, I've heard this for years, and this other people say it. I'll say it, but a lot of other people say it too. If a hard money lender who makes his money from closing deals tells you your deal is not a deal, or if they tell you to get away from it, or if they tell you you're paying too much, you know what? You probably want to listen to that advice very carefully, because a company like Jet Lending and my friendly competitors in Houston, we can pretty much tell you with about a 99% accuracy if your deals is really good or not. And if we're telling you it's not a deal, then get away from it, okay? But you're there, you got competition for this house, you need to lock it down under contract, and you're just nervous, then simply put in special provisions, this contract is contingent upon lender approval. This contract is contingent upon Jet Lending approval. This contract is contingent upon inspections and approval of the results of those inspections. There's a lot of things you can write giving yourself an out, okay? It's just a protection. Another way to do it is to fill in section 23 on page 9 of the contract, and we'll cover that in just a minute. I'm going to go into the contract a little bit. But give yourself an out on these deals, and that's all you have to do. You're legal. You have the legal right now to back out of these deals if you determine this deal is not for you, okay? So that's some pretty good ones. As far as I know, that's pretty much it when I'm buying. Let me switch gears for when I'm selling, okay? Now I'm switching gears. I'm not buying that house. I've already owned it. I'm going to sell it later. Okay. Here we go. Again, same disclosure. If you're a real estate agent, you need to disclose you're a real estate agent. And you can do that in section 4, or you can write in the special provisions, or you can do like I do and put it both. Okay? All right. Now, a lot of times you're selling through MLS. Maybe you're a real estate agent, or maybe you procure the service of a real estate agent, and the buyer's most likely going to have a real estate agent. So some of these, the buyer's representative, their agent, probably going to push back on you a little bit. So some of these work best when you're selling to other investors, and maybe it's off market, and there's not a real estate agent involved in the transaction, which is totally fine. Nothing wrong with that. So if you're selling to another investor, and you're probably not on MLS, you could be, but you may not be, probably not. I'll put this in there. Should this contract fail to close for any reason, buyer understands the seller will retain X number of dollars deposit as liquidated damages. Should the contract fail to close for any reason? I can honestly say I actually changed that one up a little bit. I say, should the contract fail to close for any reason other than seller cannot provide clear and marketable title. And usually with mine, I've already closed anyway at a title company. So I've already closed once at a title company. I know the title company don't close it a second time. That's not a fear. But the buyer doesn't know that. So you can put that in there. And shall retain the dollars deposit liquidated damages. You could say dollars is earnest money is liquidated damages, whatever terminology you want to use there, deposit or earnest money is liquidated damages. Okay. Sometimes when I'm selling some really low-end houses, I'll get a cash deal, and I don't want to pay for a title company again. The buyer doesn't want to pay for a title company again. I'll simply write in there, this contract does not involve an escrow officer or a title company. Just so, we're disclosed. Again, I'm thinking about later, should the buyer be upset with me, okay? It doesn't happen often, but it can happen. This is a really good one. This is an as-is, where-is sale. This property is a fixer-upper, and the seller is selling as-is and will not do any repairs. The seller has never lived in the property and does not have any inspection reports. So that's a really good strong one to have in there when you're selling as-is and you've not done any repairs and you don't have an inspection report. We don't normally hire an inspector to go out and inspect houses. Occasionally we will. About the only time we'll do that, at my level, I don't, if I'm buying these typical 322 bricks in the suburbs, it's, worth $150,000, $250,000. I don't get an inspector. But if I'm buying an 8,000 square foot house, that's worth $1 million, I like to get that inspection report. That's about the only time I get one. Okay? All right. If I'm not involving other real estate agents in my sales, a lot of times I want to hold the earnest money myself. It keeps me in control of the situation, gives me a little more power and leverage. I'll write this in. If I'm holding the earnest money myself and not giving the earnest money to the title company, all parties acknowledge that the seller is holding the earnest money but is not acting in any other capacity as the escrow agent. I'll read it again. All parties acknowledge that the seller is holding the earnest money but is not acting in any other capacity as the escrow agent. Okay? Again, you kind of get the flavor here. These are keep you out of jail free cards for later should the buyer ever get mad at you and accuse you of doing something wrong or not total disclosing to you. Okay? The next one is one I use when I'm owner financing. Any title policy will be solely at buyer's expense. Any title policy will be solely at the buyer's expense. When I own or finance, I try to cut the expenses down to the bare bottom because you have to. The buyer will pay for any closing cost, title policy if they want it. If they don't want it, they don't have to pay for it. We just won't do it. There's legal fees, document fees that's got to be, somebody's got to pay. I want the buyer to pay that, so I'll write that in special provisions. Okay? Here's another variation of the same thing I'm talking about. Buyer understands that the seller is not supplying a title policy with this transaction. Again, this will be in owner finance. If you're selling to a buyer coming to you from MLS who's got their own agent and their own lender, this would not apply. But this is when you're owner financing. Buyer understands that the seller is not supplying a title policy with this transaction. The buyer is free to purchase a title policy at their own cost. The buyer has received information explaining title insurance, and we have some title insurance pamphlets that we give out. Okay? Sometimes if you're selling from a yard sign, there's no agent involved with the buyer, and I will write this in there, and I'll be honest with you, I'd almost rather they have an agent, and I pay that 3%. I have learned it's just less trouble, less hassle, it's less risk. But sometimes when the buyer comes to me from a yard sign or maybe the internet, they don't have their own agent, I will write this in. Yes, for all your agents, I'm aware of the proper forms you fill out for TREC, and I understand that. But I'll also write this in. Buyer agrees that Eddie Gant is not representing them. Buyer agrees that Eddie Gant is not representing them. I'll put that in. Okay? If they don't have an agent, and sometimes another agent shows up later to represent them, and you certainly got to give that buyer the right to have that agent. But you've negotiated maybe down to the bare bones, thinking you were not paying another agent that 3%, and then another agent shows up late in the game because they talked to a family member over dinner, and you got to get your own agent, and they've already entered into contract with you. Buyer is not being represented by a realtor. If buyer chooses to later hire a realtor, the buyer will pay all of their realtor commissions and fees. And that kind of protects you there. Okay, you got to let them have that representation. And like I said, I'd just rather they have it from the get-go, but sometimes that doesn't happen. Okay, here's one of my last ones. Buyer agrees that this contract and attachments have been explained, and buyer understands is not rushed in this process. I'll say it again. Buyer agrees that this contract and all attachments have been explained. You probably should say have been explained fully and clearly, and buyer understands and was not rushed in this process. Okay? Again, keeps you out of trouble later. Let me scan over and see if I've missed anything here. A lot of times, if I know the buyer's not getting an inspection report or not going to hire an inspector, I'll put this in there. Buyer understands that this contract is not contingent upon inspections. So a lot of times I'll put that on there. Okay? All right. I'm going to hit the pause button just for a second, and then I'm going to come back and I'm going to talk to you just a little bit about the TREC contract that we all use. That's it for special provisions. I hope that's something that will help you. I hope it's something that will save you some heartache. I hope it's something that if you get accused of doing something wrong, even though you're innocent, and you get brought up in front of a judge and have to testify, that this gives you some ammunition to defend yourself and keeps you out of trouble. Those can be very expensive tasks, and I hope a few of these, and the one that just jumps out at me is the free of debris and broom clean, and you're not having to haul all the stuff off later that they promised you they were going to handle, and it saves you a little bit of money. So those are some pretty good ones. I had to read them to you. I don't have some graphics here unless somebody puts them on later for me, but hopefully that's good stuff. And we'll go hit the pause button just for a few seconds here, and I'll come back to you and talk to you about the TREC contract. Eddie Gant, Jet Lending, be right back. Thank you. Okay, I'm back. That's a quick break. Y'all probably thought it was 2 or 3 seconds, probably about 15 minutes. Kind of caught my breath there a little bit and took care of a few things. Okay, let's talk about the TREC form, Texas real estate contract. I'm a licensed agent, been a licensed agent for probably 15 years. Back when I got in the business 21 years ago, generally speaking, investors were not agents and didn't want to be agents. That all changed now. Most of the investors I know are agents, and the trend is if you're a real estate agent, if you're a real estate investor, you go ahead and get your license, which is fine. That's what a lot of us started to do 15 years ago. All right. I get asked all the time, can a non-agent use these forms? Again, none of the same disclaimers are, I'm not an attorney. Don't take legal advice from me. I'm just a man of experience trying to give you some good advice. The forms, the TREC form used to say at the bottom something like, these forms are intended for the use of licensed agents. Intended. Did say shall not, wasn't mandatory. The website I looked on, last time I looked at the other day, the TREC website said something like, these forms are primarily used by real estate agents. Didn't say non-agents couldn't use them. Okay, so you can use them, in my opinion. I think most real estate attorneys would tell you that. All right, so you're clear there. All right. The first thing I want to point out, as I mentioned a couple times earlier, Section 4 is called license holder disclosure. You can simply write in there, that you hold a real estate license and you're also a principal in the transaction, or you're one of the owners of the buying entity. No problem there. Section 5 is earnest money. This changed. The wording on this changed about 2 years ago. It used to say buyer must deposit earnest money at the title company within a reasonable time. Reasonable time. And that just caused all kinds of fights. Okay. Now it says within 3 days. So that's a contractual obligation of the buyer to get the earnest money to the title company within 3 days. Okay. So let's take an example. When's 3 days? Let's say you execute on Monday. Okay. You got to get there within 3 days. You don't count Monday. Tuesday, Wednesday, Thursday. Got to be there by the close of business Thursday. Okay. If you execute on Monday within 3 days. Okay. It says if the buyer fails to deliver the earnest money within the time required, which is again 3 days, seller may terminate. Well, you can. I don't know if that'd be the smartest thing to do in the world, just because the buyer, didn't get their earnest money over there within 3 days. I don't think I'd go and terminate that, but you could legally. If they don't get it over within 2 weeks, then that's a different story. You may not have a real buyer. Okay, so that's probably all I really got on page 1 is I'm not, the objective here is not to teach you the TREC form. The objective is to show you some pointers and some tips here, okay? Most people don't know this. On page 2, it talks about delivery of the title commitment for title insurance purposes. And I'll ask this question a lot in front of an audience. Who's responsible for getting the title commitment to the buyer? And almost everybody will say, well, it's the title company's, Well, the title company does it. They do it as a service for the seller. But it's very clear contractually, because the title company does not sign your contract. A buyer and a seller signs a contract. But it's very clear that the seller is responsible for furnishing to the buyer a commitment for title insurance. It's very clear. So it is the seller's responsibility. If the title company does not do it for you, Mr. Seller, you can get mad at the title company, but it's your fault contractually. It's your responsibility, Mr. Seller. Okay. The contract does say that if you don't get it to the buyer in time, that there's an automatic extension built into the contract. Most people don't know this. Should the title company be slow in getting the title documents and everything to the buyer, that it will be automatically extended up to 15 days, meaning your close date can be extended up to 15 days or 3 days to allow the delivery of those documents. So just be aware of that, up to 15 days. So be aware that that's there. I'm on page 2 of the TREC sales contract, the 1 to 4. It talks about the purchase and delivery of a survey. C1 on page 2 talks about if within X number of days of contract, seller to furnish to the buyer their existing survey, seller to furnish to the buyer and the title company their existing survey. What you need to understand here is there's another block down here that says the buyer shall obtain a new survey, and it's big letters, buyer or seller or buyer's expense. You can check, buyer's expense, but that's what that really means is if the seller provides the buyer a survey and it's not acceptable to the buyer or their lender or the title company, then the buyer will get a new survey at buyer's expense. But up above it, and that's a trick, because up above it, it says if the seller fails to furnish the existing survey. So if the seller don't furnish a survey at all, even under C1, if the seller does not provide the existing survey, then the seller is paying for it. It says it very clear, even though down below it's checked buyer's expense. If the buyer's expense is checked if the survey furnished by the seller is not adequate. But if the seller does not furnish a survey at all and you check this box, the seller's going to pay for it. Just be aware of that. Okay? Down below, there's number of days for a buyer to object to the title documents. If you're selling, you want that number to be as small as possible. If you're buying, you want that number to be as large as possible. Okay? I normally just put in 3 days. 3 days is certainly adequate for a buyer to review the title commitment and any other documents that they're supposed to be getting from the title company. Okay? That's kind of a low impact one, but here's a big one. Seller's disclosure. It's on page 4. It says you got 3 options on the seller's disclosure on this contract. You can check box 7B1, which says the seller has provided the buyer and the buyer has received a seller's disclosure. That may be one of your options. Box number 2, the seller has not provided the buyer or seller's disclosure yet, and they agree to do it within blank number of days. And I'll typically see the number 7 to 10 entered into that. Meaning, you signed and executed a contract today, seller's lazy, seller hasn't filled out a seller's disclosure and they hadn't done it yet, so they check 2 and say, we'll do it within 5, 6, 7, 8, 9, 10 days. You can do that. Or you could check 3. 7B3, which says sellers not required to furnish a seller's disclosure on the Texas Property Code. I can only think of two reasons why that one's checked. It's inherited or it's a foreclosure, and the lender is the seller. Those two you typically check in number 3. But I'm going to back up to number 2. If I'm the seller, I will always check box 1, meaning I have filled out my seller's disclosure and I've given it to the buyer or the buyer's agents, and we check box 1. That's when I'm selling. I never check box 2, because I'm never going to be accused of being lazy, but it ain't about being lazy. Here's the reason: it's legal. If Mr. Seller is lazy and does not have the seller's disclosure ready at the time of execution of this contract, and you check number 2, and you check within 7 days, and Mr. Lazy Seller waits 7 days to hand it to Mr. Buyer, you just gave Mr. Buyer another 7 days of free option period with the unrestricted right to terminate. Most people don't know that's in there. This is how it impacts anything I'm talking about today. Don't get lazy if you're selling. When you sell your house or execute a contract to sell your house, have that seller's disclosure ready to go at that time. Give it to them. Check number 1. If you don't, you just gave them a free 7 days for the unrestricted right to terminate because you're lazy. So don't ever do that. If you're buying, then I guess you could let Mr. Seller get lazy and check number 2, and you just bought yourself the unrestricted right to terminate for 7 days after they give it to you. It's not 7 days from the execution of this contract. It's 7 days from the time Mr. Seller delivers the seller's disclosure to Mr. Buyer. Okay? That's pretty darn powerful stuff right there, and most people don't know that. Okay? All right. That's worth your time to watch the video today. All right. Okay. You got your own before. Oh, let me back up sales disclosure on something. Let me put my buying hat on again. I'm Mr. Real Estate Investor and I'm buying. Do I get a seller's disclosure from my seller? Absolutely. And I am shocked and just shocked beyond belief the number of young, new real estate investors that don't think that's important. It's huge. Let me give you an example where it's huge in Houston, Texas. You don't get a seller's disclosure from the buyer. From the seller. I misspoke. You're the buyer. You're talking to Mr. Seller. You don't think it's worth your time to get a seller's disclosure. Buy the house, whatever, sell it. The sellers told you never flood. That's what they told you. You sell it to somebody else, you disclose to them no knowledge of prior flooding. And they move in the house. They talk to that neighbor, and that neighbor, and guess what? 19 big flood, one of the big ones before we were all into this 1994 house flooded. Of course, we just had Harvey. Just about anything that flooded in 94 flooded in Harvey. But you didn't even say Harvey, it don't matter. You disclosed that you didn't have knowledge of prior flooding, and you didn't. But they move into the house, talk to the neighbors. Yeah, all the houses on this street flooded, and they think you lied to them. You're evil now, and they come after you. They sue you. If you got a seller's disclosure when you bought it, where the prior owner that lived there for 25 years disclosed to you no prior flooding, you've got a defense mechanism. And how do I know this? Because it's happened to me. I handed that old seller's disclosure to the people I just sold it to and showed them I didn't lie to you. That's all I knew. I didn't live in this house when it flooded. I was told it didn't flood. Diffuses the whole situation and gives you a document in the court, to defend yourself. You don't get that seller's disclosure when you buy it. You do not have that tool. You do not have that defense mechanism to protect you later. It's very important. Okay? All right. When I'm closing, I talked about this a little bit earlier about the broom clean and free of debris. Sometimes you get into situations where you're going to lease back for a month, you're going to give them a week to move out. That's all fine. We all do it. But I'm going to warn you on one situation. It don't bother me at all to give the seller a little bit of time to get out or lease back. It don't bother me at all. It don't bother me at all to take a house with a tenant. But let me tell you who I don't close and fund with that's in that house, because it's a problem. Family. They're not the seller. They're family of the seller. Whatever family is, nephews, nieces, brothers, cousins, whatever. I will not close and fund on a house that I'm buying with family members still there. And I'll tell the seller, it is a problem. Just heed my advice. If you don't, you're going to find out one day that's a rough go if they refuse to leave. Okay? Just always remember that. Section 23. I think I said page 9 earlier. It's page 8. I knew it was page 8. Just misspoke. Most powerful paragraph in the TREC contract, termination option. You need to use this paragraph totally differently whether you're buying or selling. For when you're buying, use this to give yourself some protection till you can maybe get someone out there that's a little more knowledgeable to look at the house if you're uncomfortable with it. It gives you the opportunity to buy an option period, an unrestricted right to terminate. Some people refer to it as an inspection period. But basically, you give X dollars for X days. What I see most commonly is $100 for 7 days, $50 for 7 days, $100 for 14 days. If you plan to wholesale and assign the contract, you're going to need more time in that. You might give a couple of $100 for 30 days, 45 days, but you need to explain that to the seller if you're truly going to try to assign the contract. I don't think it's ethical to do this and not tell the seller. That's my opinion. Okay, so this gives you some time to inspect, make a decision, make an educated decision if this is a transaction you want to go through with, and that's what the paragraph is for. If you're selling this property and your buyer's coming from MLS with their own agent, they 99% of the time is going to have an option period, and most often you'll see them put in $100 for 10 days. I don't like that. That's not enough money in too long of a period of time. I counter every time at 200 or 250 and give them 7 days. And I get it most of the time. Sometimes I get pushed back, and then you got to make a decision. So you got to use it differently if you're buying or selling. Again, if you're buying, gives you some time to get some help out there to really look at the house. If you're selling, you're going to have to probably put up with this when they have a real estate agent and give them the rights. It's just no other way around it. Now, let me tell you what this paragraph says. Let's say you're selling and they agree to give you $100 for 7 days, and you go ahead and accept that. That $100 has got to be paid within 3 days, or this option period does not exist. You need to go through and you need to read every word of this section 23. It says, if buyer fails to pay the option fee to seller within the time prescribed, which is 3 days, this paragraph will not be a part of this contract, and buyer shall not have the unrestricted right to terminate. It's very powerful. I'm going to say of all the sales contracts I signed, more than half, more than 50% failed to get the option fee paid in time within 3 days. They failed to do it. There's only 2 people today, and I'm going to emphasize today here in just a second, that according to TREC can accept option money. That's seller and seller's agent. Notice I didn't say title company. Title company is not an authorized person to receive option fees, option money. Now I hear rumblings on the street, they're getting ready to change that to allow the title companies to accept option fees. That hadn't been implemented yet, but I hear it could possibly be coming. But use that to your advantage if you get in that situation. You also need to understand that if you put $0 down for your option fee, that it's not valid. It says it very clearly in here, if I can read it in this dim lighted room here. If no dollar amount is stated as the option fee, then this paragraph is no longer a part of the contract. It says it right there. So you can't put 0. You got to put, it doesn't say a minimum. I guess you do $1, but I would never put $1. You got to put something legit. Remember, if you get brought up in front of a judge later, I don't think $1 is going to buy you much goodwill from a judge. Put $100, $150, $75, you're probably okay. So that is the most powerful paragraph in the TREC form. I'll say one thing about the financing addendum that you need to know. The financing addendum is both for the approval of the buyer and approval of the property by the buyer's lender. Okay? You got to obtain credit approval. You got to obtain property approval. There's a section on the bottom of page 1 that tells you how many days that the buyer has to get credit approval. I try to keep that 14 to 21. They'll always ask for 30. And I have to re-educate an agent and tell them, hey, that's only for credit approval. It has nothing to do with the property. Because they say, oh, we can't get an appraisal within 14 days. Well, appraisal over here. You can obtain credit approval, but your property don't reach value per the appraisal. They're subject to conditions. It's a sad thing. Per this financing addendum, that buyer has the unrestricted right to walk and get their earnest money back should the property not appraise or have subject to conditions, that's got to be remedied before the lender will close. You can do them or not do them. You're not contractually obligated to do any repairs per the financing addendum. But if you don't, you may lose your buyer because the buyer's lender is not going to close. Be aware that in the contract on this inspection period, if you're the seller, when you sign the TREC contract, you are committing yourself to have all the utilities on. You may not have gas on. You may not have a gas meter. So you need to understand that you're committed to get all utilities on if all utilities or whatever utilities are present. But, unless you omit it from the contract, just be aware of that. It's been fun. It's been fast paced. I could talk another 4 hours on this, I think, but that's some tips. Again, not an attorney, don't take legal advice. Maybe that's something that's going to save you some money or save you some heartache or both. I am Eddie Gant with Jet Lending here in Houston, Texas. We would love to loan you some money for your flips or your rentals anywhere in Texas and beyond. And if you've got a bunch of money laying on the sidelines and want to invest very safely for a fixed rate of return, talk to us on that. Phone numbers and email are up here. I look forward to seeing you. I can't wait to get back to live events. I'm tired of the virtual. I like to shake hands and high five and have a beer and talk to you guys and ladies. So call me anytime, okay? You can reach me. And I'm not hard to reach. I do try to get back with everybody that calls or emails me. I'm not perfect. I may miss one every now and then, but I try to get back with you. We don't mind helping you. Thank y'all. Have a good day. Y'all have a great day and a good evening, okay? Bye-bye.
All right. Thank you so much, everybody, for watching that amazing webinar. And now we have come time for questions and answer. Alex, are you ready for that?
Yeah, it looks like we got some that came in.
Okay. So the first question, what are the possible reasons one can get out of the TREC contract buyer after the 7-day options period?
Well, just like what Eddie was talking about, and of course he went over that, but really look over your contract. You can get out of it if you were not provided the correct seller's disclosure in time, if you were buying the property. B, if they cannot furnish adequate and marketable clear title. Anything that's in your contract, and this is where a lot of the answers come from to anybody's questions is when you're dealing with this contract, all your outs are really written right there in the contract. So do not rush through a contract, and just, you got to be able to read it and be okay with what you can and can't do, because you can opt yourself out of these ways to get out. The firm way is for that 7-day one. The easiest way is if there is not clear title, you have the right to rescind the contract and receive all earnest monies and things like that back.
Okay, perfect. Next question, how do I invest my capital with Jet for the fixed income? Would you contact y'all?
Yeah, so it's really Johnny Hayes. He handles everybody. He handles all the Quest people that come in and do some private lending with that. So what I'll do is I'll put Johnny's number in like the chat, and you guys text him, email him, so you can kind of pick out what type of investor you're trying to be, to see what's right for your for what you're trying to do. So you can call him, text him, just especially if you're with Quest, make sure say, hey, listen, I'm Billy or Sarah with Quest, I'm trying to get some information on how to be a private money lender, and he'll call you right back.
Awesome. Thanks so much. Vacant with belongings. Should we ask for the key, like if they are in the middle of the move?
All right. So here's where Eddie was talking about like a business decision. You kind of have to gauge your seller, okay, and use kind of common sense. If this is a house where there's a lot of nice things in it and things like that, you may want to forego that, okay? And it's not because something could happen, but do you want to take the responsibility if something does happen, whether you're involved or not? So if they are in the middle of a move out, what I would do is most of the times go with your contractors, go with like appraisers, go with them, make sure that you have accompanied them. If you're going to do like with a possible buyer, so like you got the approval to market the property, just make sure you're present. And that would be a way to do that, because everybody's friends until something's wrong, and it's not what you know, it's what you can prove. So you do not go into any place where someone's like, well, they said they put the key back in the lockbox. You don't need that. How many of you people that have gone to look at houses and the key was supposed to be in the lockbox, it wasn't there, or there was a window broken, or the doors were just open, you just walked in? So don't put yourself in that kind of liability. If that's the case and they're moving out and they're actively, if you have to do this and have to go in there, make sure that you go with everybody that's going.
Okay, perfect. How many days tops can an option period be? Up to 30 days?
An option period can really be as much as you negotiate it to be. The longer the option period, unless, no, this is outside of the commercial realm. This is outside if you're buying like a mini mall or something like that. But in 1 to 4 single family type of stuff, if you're having a very large option period, one, you're going to have a really hard time negotiating, especially if they have an agent, because like, why do you need a 60-day option period? What's going on? If you do end up asking for like 30 or 60 days of option, you should probably have to put up a substantial earnest money, which is probably going to be around 10%. So can you get those long option periods? Yes. Will you have to pay for them? Yes. If you have a good team around you and you're willing to negotiate and move quickly on properties, I feel that's going to hinder your process on acquisition. You should be able to go into a house, get a 3 to 5 day option, put the appropriate money down, and move. If you're having issues 30 days, either A, they're going to think that you're just wholesaling the property and you're going to lose out on the contract, and B, you're just going to, you're going to end up putting money down and most likely losing it. So don't do that. Put a good number down where it's reasonable to inspect and have options of the property. As you can see, there's plenty of things in the contract, if you go through it nice and slow, that will save you from big things like surveys, title issues, and title insurance issues and things like that. They're all within the contract. So you can extend all those, things of warranty of your money if you just fill your contract right, and you can still negotiate better with a low option period. Okay,
great. Thanks. I've had a couple of people ask this. Does jet lending work in other states or just Texas?
We do, but Texas is a very unique state. So Texas is one of the last, if only, the only true loan to value state. So that's why Jet can do 100% financing, because we're an actual true loan to value lender. You'll get a lot of lenders that say, oh, we'll do up to 75% ARV, but they're 80 or 90% loan to cost. So it doesn't matter what the LTV is, because you're still coming out of pocket at closing. And so every other state is a loan to cost state. So we won't be able to do 100% financing in other states, but we have loan to cost options in all 50 states.
Wonderful. Thanks so much. We're going to do one more question just for time's sake. And everybody that we didn't get to your question for, Alex, if you wouldn't mind putting Jet Lending's information in the chat box, that would be great, so they can reach out and ask those questions. But here's going to be our last question. If the seller provides seller disclosure, but they mark it incorrectly, instead of Y, they put X, does this need to be corrected so there is no confusion on yes or no? And when they correct this and send it back, does the option period go forward 7 days?
I got to read this.
That was a long one.
If the seller provides a seller disclosure, but they mark it incorrectly, instead of Y, they put X. Does this need to be, let's see, it's gone now.
Oh, I'm sorry. I put it in answered.
Okay.
It's an answered at the bottom.
Okay. All right, let's see here. I'm sorry, I got to click it there because I have to read this. Does it need to be corrected so there is no confusion? Yes or no? And when the corrected this is sends it back, the option period go forward 7 days. Okay. Anytime there is an issue, so now you're talking about seller's disclosure. There has to be what's called an amendment to the contract. Okay, so you'll file an amendment, or you most likely, if it's the seller's issue, they have to file an amendment. If you're using an agent, that's part of the reason why they're getting paid, is that you get with your agent, say, listen, I'm aware that this is an issue in the seller's disclosure. This needs to be changed. The selling agent would then make sure the buyer fills out a new seller's disclosure and amends it to the contract. Because I've never seen it happen. I mean, I used to sell 18 houses a year, and just while I was doing loans. And if there is a change into the seller's disclosure, I do not know if it automatically recycles the 7 days. Because in the verbiage of the contract, it says that you received it, but you're saying you didn't receive the right one. So this is where it comes down to anything in this contract. When you find, it's a great question because it brings up a very specific point. When you want to make change and amendment, make sure that you amend the contract to what you want. So you're going to amend that seller's disclosure. So you're going to request a new seller's disclosure, and you're requesting the recycling of the 7 days to that point of the contract to be restarted once received. So you never want to get involved in a legal jargon argument. Just like Eddie said, it just says shall not or shall or something like that. It's always very choice words that you use. So what you're going to do is anytime you want something, you're going to list out exactly what you want in bullet points. So it's very clear that you've requested this and these things have to be met to resolve the issue. So if you have a seller's disclosure issue, then have the agent repurpose the seller's disclosure, and then ask in the amendment that those 7 days be recycled.
All right. Well, thanks so much. And thanks so much for being here with us, Alex, today. We really appreciate it. Great presentation, of course, by Jet Lending as always. And thank you to everybody who joined us today. It was a pleasure to have you. And we will be here same time, same place next Saturday at noon Central. So thank you, everyone, and have a wonderful weekend.
Bye. Thank you again for having us.
Bye, guys. Thanks so much.